Hola, buenas tardes, bienvenidas, bienvenidos. Es un placer poder
Good
estar aquí.
afternoon. Welcome, everybody. It's a pleasure to join up again on our cycle of talks on the Sharia. This is our last talk this semester. The next one is scheduled for the 14th of September. This time, we have with us Intisar Rabb from the Harvard University. Thank you so much for joining us in Casa Árabe. And in the name of our colleagues, we're really happy to have you. Last week, on the 22nd of June, we have the pleasure of talking a bit on the more contemporary part of the, let's say, implementation of the Sharia in the legal framework in Spain. I think it was a very interesting talk from Fernando Amerigo. We have the talk on our YouTube channel. He's from the Complutense University in Madrid, and this has been shared also with the institution in Cordoba and on the social media. But today with us is Intisar Rabb. She will be delivering a talk on a topic, basically Islamic crime and punishment, principles and practices. And without further ado, I'll keep it short because obviously she is the star, not me. But before that, let me greet Nina Serrano yet again, as during the 9 sessions, because she did a double session. She's been in charge of research coordination and of the talks proper that we have been organizing. And she's also in charge of what is still ahead, the more educational part of this. Our magazine, Awraq, that will publish all the talks that we have been dealing with. So she's with us virtually, of course. And by the way, let me just greet everyone that is following us through our YouTube channel and through the social media of Casa Árabe. I would really like you to follow us and to talk to everyone else about what we do here. So, enough on my part. I'll give the word to Delfina so that she can introduce our speaker today. Thank you, Javier. Thank you also to Casa Árabe for this conference cycle. And thank you all to our audience that has been following these talks so intently, either being in the room, in person, or also virtually. And obviously, our thanks to Professor Intisar Rabb, who has found time in her very busy agenda to participate in this conference cycle. Now, each participant in this cycle has a specific profile. In the case of Intisar, obviously, she has a very important research work concerning the Sharia. Criminal law is one of her specialties, and the topics that she has been dealing with in this much broader topic of the Sharia. Well, she's a researcher and she is also a teacher, but furthermore, she's heading a number of very interesting projects that want to foster not only research into Sharia, but also are to be understood as an outreach effort so that university students in the first place, and also the general audience, get to know more on this topic. So very important research, outreach of research on Sharia. Hopefully this will help to fill lacuna and to correct distortions and misconceptions that do oftentimes exist regarding such a complex topic as the Sharia. She also heads a number of very interesting projects to apply the most sophisticated technologies to the study of the sources, the written sources of Islamic law. That is, let's say, digital humanities, in a word. And furthermore, she is a law teacher, a history teacher, and she's the expert in the law school for Islamic law. She has published on Islamic law, but also on US law, penal law, compared law, and the legal Islamic law canons. And then she has also dealt with doubt in Islamic law. She has published this, has been published in the Cambridge University. As I said, she's the director of the Islamic Law Blog and also of SHARIAsource. And that's an online platform that is intended to facilitating research on Islamic law by using data science tools. She received a BA from Georgetown University, a JD from Yale Law School, and an MA and PhD from Princeton University, all of them major institutions. Furthermore, she has conducted research in Egypt, Iran, Syria, and also elsewhere. So without further ado, let me hand over the microphone to Intisar. And yet again, let me thank you for joining us today. We're eager to listen to you. Go ahead, please.
I want to thank you very much, Professor Serrano, and everyone else who is at Casa Arab that is participating in this conference and for inviting me to speak with you today about this, what I consider to be a very important topic on Sharia and criminal law, with a focus on medieval Islamic history. And today I'd like to start with a case. This is a capital case that I think will illustrate some of the principles and practices of criminal law on which I'll focus. So the most consequential case of capital punishment that I have uncovered in the late Mamluk period unfolded under the very last Mamluk Sultan, Sultan Ghawri, Qansuh al-Ghawri. He ended his reign in 919, or the case unfurled in the year 919 or 1513. 3 years before the coming of the Ottomans. So in this case, a man who was in love with an apparently very beautiful wife of a Hanafi deputy judge discovered that the woman was having an affair with a local Shafi'i deputy judge. And he reported it to the husband. When the Shafi'i judge confessed to committing adultery through this affair, he received a very harsh sentence in the courts from the judges. They sentenced him and his lover to being flogged, being paraded around the city in disgrace, and to paying a fine of 100 dinars or gold coins. But the Sultan, he was dismayed by the underlying incident and the punishment, and he thought it was all too lenient. He wanted a harsher capital punishment to show that he had control over his realm. He tried to order the judges to sentence the two offenders to death by stoning. This is a punishment that had never applied to an accusation for adultery in the very long history of Islamic law, for reasons we'll discuss later. The chief judge ended up rejecting the Sultan's orders. Instead, the chief judge issued a fatwa quoting prophetic reports, prophetic hadith, that support avoiding the criminal punishment. This judge was drawing on the doubt canon, qawāʿid shubha, that in fact required such punishment avoidance whenever there was doubt. Here, doubt was defined as sincere repentance on the part of the perpetrators. When the chief judges from the other three schools endorsed that fatwa, the Sultan surprisingly dismissed all four judges. He flogged the chief judge who issued the fatwa, and he ordered the offenders to be executed by hanging. Now, this incident was particularly notable because it effectively resulted in the dissolution of the entire judiciary for not stoning. And by some measures, it was emblematic of the dissolution of the Mamluk Caliphate itself. Here, the Sultan had tried to assert his own authority over the criminal law of Shari'a in a way that instead represented political excess, and it diminished his standing and his legitimacy. The case also provided a pretty rare illustration of one area in which doubt jurisprudence, this practice among judges to avoid criminal punishments in cases of doubt. This doubt jurisprudence worked to place constraints on executive excess, at least initially. The pushback from the chief judge and the fatwa against the Sultan's punishment underscored the limits of the Sultan's legitimate use of stoning punishments to project authority and to assert control. Even though the offenders were ultimately executed, the Sultan could not rely on the legitimacy that would have been conferred by Hadood punishments had he gotten the interpretive blessing of the jurists to do it, because the local experts on Islamic law refused to co-sign on his attempts to do so. The Sultan's dismissal of the judiciary had violated the balance of the political interpretive divide that together made up the Shari'a scheme for Islamic criminal law. And accordingly, it had damaged his reputation in a way that, as other Mamluk historians have argued, injured his standing on the eve of the Ottoman takeover and contributed to his fall. So this case, moreover, illustrates a striking feature of Islamic criminal law that I will aim to unpack over the course of this talk. So the striking thing about medieval Islamic criminal law is that it featured a jurisprudence of doubt and lenity, and then a set of political practices of control and severity. Now, in most studies of Islamic criminal law, the principles, practices, and justifications for punishment typically operate in silos, separated from a wide plane. This lecture today explores the ground where they meet. Specifically, my talk focuses on the criminal law principles and practices in Umayyad Syria, ʿAbbasid Iraq, and Mamluk Egypt. I aim to illustrate what is behind this striking feature of medieval Islamic criminal law that I began with, namely this contrast between a jurisprudence of doubt and lenity on the one hand, and political practices of control and severity on the other hand. I argue that by addressing this contrast, we can gain more insight into the field of Islamic crime and punishment. We do so by approaching the field with greater attention to the principles and practices and some attention to the justifications for Islamic criminal law. I therefore seek to address 3 questions, and my talk will follow these 3 areas. First, to address the principles. I ask, what are the basic principles elucidated in Islam's criminal law on the books? Second, to address the practice, I ask, how can we explain and detail the extent of divergence between Islam's principles for punishments and the practices we see in these various societies historically? And third, to address the policies, I ask why. That is, what can we say about the justifications that explain each? So first, as to the principles, what are the basic definitions and principles of medieval Islamic criminal law? There are only 3 categories of laws that the jurists formally regarded as divinely sanctioned criminal laws, that is, laws on the books. Those 3 categories are, number 1, Hadood Laws, that is, text-based fixed crimes and punishments. Number 2, Qisas Laws, that is, text-based capital and corporal punishments or fines for wrongful deaths or serious personal injury. And number 3, Ta'zir Laws, discretionary crimes and punishments that are not text-based. They cover everything else. They're undefined in the text, but they may incur a discretionary punishment. These 3 categories form the basic outline of what Muslim jurists considered legitimate crimes and punishments under Sharia. Now, a 4th category of crime fell under executive jurisdiction called siyasa. So like ta'zir crimes and punishments, political rulers punished siyasa crimes and punishments according to their own discretion. Siyasa policies overlapped with ta'zir laws, making it so that early jurists and executives shared jurisdiction over the 2, until the executive gradually used siyasa, as we'll see, to swallow ta'zir laws and eventually other Islamic criminal laws altogether. Let's take a closer look first at Hudud and Qisas laws. As for Hudud laws, Muslims believe that God directly legislated them as a series of fixed mandatory criminal sanctions in Islam's foundational texts and in related early practices. So it's important to consider that even though jurists claim that these laws have textual origins, not all Hudud laws were present in the Quranic text. Hudud crimes include just 4 to 7 laws, and they are as follows. The first 4 are, first, zina, illicit sexual relations, that is, fornication or adultery. There's a Quranic punishment at 24, Surah 24, verse 2, that is 100 lashes with a whip. But jurists overlaid a local biblical norm of stoning for adultery onto the Quranic punishment. Second is qadhf, defamation, and specifically false accusations of sexual impropriety or of zina. That's laid out in Quran, Surah 24, verses 4 to 5, which also specifies a punishment of 80 lashes. Third is sariqa, or theft, for which the Quran in Surah 5, verse 38, specifies the severe corporal punishment of hand amputation. Fourth is shurb al-khamr, wine drinking, which the Quran at Surah 5, verse 90 prohibits, but it doesn't ever specify a punishment for wine drinking. Early jurists instead pointed to hadith reports to determine a punishment of 40 lashes as being appropriate, And the second caliph then increased that amount to 80 lashes by analogy to defamation as the probable result of drunkenness. So to these basic 4 crimes, some Muslim jurists added 3 additional text-related laws. These 3 did not always count as hudud crimes proper because they guided executive policies, which typically count as falling within the siyasa jurisdiction, and because they involve some measure of discretion. So the 5th is hiraba, or qat' at-tariq, highway robbery or brigandage. The Quran at Surah 5, verses 33 to 34, authorizes a range of punishments that a ruler could choose from: cross amputation, crucifixion, exile, or death. 6 is ridda, or apostasy, which the Quran in Surah 2, verse 217, condemns as a spiritual wrong to be dealt with in the afterlife. The Quran never specifies this worldly response either, aside from the war context, in which case it authorized the use of lethal force against so-called apostates who signaled treasonous threats to the state by denying its political authority or their own willingness to abide by the laws of the land. So this was a time when religion meant citizenship. Apostasy became a crime because Muslim jurists extended the rules of battle to the rules of ordinary criminal law. They therefore criminalized apostasy and later blasphemy, that is, statements rather than acts, and both counted as capital crimes. Finally, number 7 is Bari, rebellion. This was ironically perhaps not a crime at all, strictly speaking, though it is mentioned in Quran, Surah 49, verses 9 to 10. When rebels acted against the state for just cause or for reasons that they could assert as a plausible excuse, Muslim jurists regarded rebellion as a legitimate way of responding to an oppressive or usurping ruler. Rebels who acted without a legitimate reason, now they were to be punished as criminals, specifically as highway robbers. Islamic law's second category, so all of that was hudud laws and related fields. Now to qisas. So Islamic law's second category of crime, qisas laws, they regulate acts of homicide and personal injury. These laws are not considered fixed hudud laws because the Quran in various places, so in Surah 2, verses 178 to 79, Surah 4, verse 92, and Surah 5, verse 45, they all provide for either in-kind punishment or financial compensation for bodily harm or homicide. So qisas laws then authorize in-kind punishment for injuries. You think of an eye for an eye or a tooth for a tooth, the biblical norm, or capital punishment for intentional murder. Unintentional killings and injuries, or those that the victim or her family chose to forgive, reduce any in-kind punishment to financial compensation called diya or aql. So now we turn to the 3rd and 4th catch-all categories of crime in Islamic law, ta'zir and siyasa. These categories encompass an ever-growing set of offenses accompanying a range of discretionary penalties, again called ta'zir amongst judges and jurists, and siyasa among executive authorities. All of these laws were extra textual in that they had no explicit grounding in Islam's foundational texts. The only limit to these laws was the framework set by the general principles of hudud and qisas laws, and by reference to the dominant interpretive principle governing Islamic criminal law, the doubt canon that I mentioned at the outset and to which I now turn in more detail. When we consider the contrast between harsh punishment theory and light application in Islamic courts, and then when we consider the contrast between light punishment principles amongst jurists and harsh punishment among political rulers, we have to wonder why. And to explain this contrast, it's important to understand how jurists and judges sought to interpret criminal laws and whether and how political rulers disregarded that interpretation. The jurist's main tool for interpretation of criminal law was through the doubt canon, qawāʿid ash-shubha. It's a broad-ranging legal principle requiring judges to avoid criminal punishments in cases of doubt. Idrul Hadood bish-shubahat. Now, jurists use this principle throughout all notable Islamic legal texts and fatwas interpreting criminal law throughout Islamic history. In doing so, they created what I've called doubt jurisprudence, which itself emerged from textual principles and experiential practices that jurists extracted from Islam's earliest period. So it too is a founding text of sorts. Over the centuries, Muslim jurists defined doubt to include over 60 types of textual, interpretive ambiguity, evidentiary infirmity, and procedural errors as defined in any one of Islam's multiple schools of law or madhabs. That is to say that according to Muslim jurists, doubt came to apply to such disparate areas as questions of facts, questions about voluntariness, questions about intent, questions about all manner of justification and excuse, including contractual confusion, coercion, duress, forgetfulness, ignorance, incapacity, insanity, mistake, negligence, self-defense, and even, as we saw in the first case, repentance or remorse. When addressing criminal cases, the doubt canon instructed judges and jurists to consider each of these factors and to consider them to be manifestations of doubt, which would require judges to avoid punishment at various stages of accusation, trial, and sentencing. However, as expansive as this jurisprudence of doubt was, the doubt canon did not always dismiss punishment altogether. Even though the doubt canon required that a judge avoid the fixed criminal punishments whenever there was one of these types of doubt, that same doubt canon allowed judges or executives to impose ta'zir or siyasa penalties instead. So it's worth turning to look more at what the ta'zir and siyasa penalties were like in practice. So we turn to those practices now. What was the basis and extent of executive power over punishment? So theoretically, it derived from a rule of necessity, that is, the necessity that government maintain law and order in the public interest, maslaha, and thereby uphold Shari'a. Medieval Muslim jurists thus regarded the executive to have had shared jurisdiction over and discretion in enforcing discretionary punishments as a delegated power. To be legitimate, all discretionary prosecutions and punishments were to be limited by moral norms that, based on their interpretation of Shari'a, the jurists aimed to establish or to reinforce. They called this derivative delegated power to the executive siyasa shari'iyya, that is, executive power authorized by Shari'a. But practically, executive officials could, and they historically did, operate well beyond the Shari'a framework for criminal law, as we'll see. In fact, we can say that historically, executive officials dominated criminal law proceedings and punishments in Muslim societies. Caliphs and their agents exercised virtually unlimited discretion with minor exceptions, to punish a virtually unconstrained set of offenses, from ordinary and extraordinary crime to personal slights connected to and separated from politics, and to violence on and off the battlefield. So to see how we now turn from discussing the broad criminal law principles and policies to discussing the criminal law practices from the executive with examples of each. So as for executive practices, I've divided the punishment types we see into three categories: corporal, capital, and carceral. We start with corporal punishments. Flogging was a common medieval corporal punishment for a variety of offenses in the Near East and beyond, both before and after Islam's advent. Law enforcement officials used flogging and other corporal punishments for a wide range of crimes, and there was only a loose connection to Hadood Laws authorizations for ordinary crimes. Examples abound in ʿAbbasid Iraq among both judges and political officials. For instance, judges in 9th century Baghdad reportedly ordered petitioners to be slapped for contempt, that is, for violating the required decorum in judicial settings. ʿAbbasid judges also used slaps to discipline losing parties in debt proceedings and to force them to pay taxes or to pay private monies owed. In Seljuk society, beginning in mid-11th century Persian lands, executive officials seem to have regarded flogging as too light a punishment for most ordinary crimes. Instead, they used it to punish their military officers or respectable scholars as an almost literal slap on the wrist. One example relates to Nizam al-Mulk. He was a famous Ghaznavid prince who became the vizier for the Seljuk ruler Alp Arslan. And in his book, he reports that a market inspector, a muhtasib, at the court of Mahmud of Ghazna, flogged a military officer with 40 lashes for being drunken in the market. But with the coming of the Mamluks after the fall of the Abbasid Caliphate in 1258, flogging seems to have made a strong comeback. Mamluk officials used it to punish false testimony at trials, to extract confession for trials, and as a law enforcement technique to respond to crime outside of the context of trials altogether. In fact, sultans and their agents fairly regularly use flogging to punish offenders without trial. For example, in the year 832 or 1429, Sultan Barz Bey himself ordered several disgruntled soldiers to be flogged for inciting an attack on their commanding officer. A decade earlier, when a baker sold bread weighing less than it was supposed to weigh for full price to one of the Sultan's secretaries, the muhtasib flogged the baker immediately without trial. As for more severe corporal punishment of hand amputation, the Doubt canon rarely authorized it, but in the historical sources, we can observe a pattern of judges avoiding punishment, but executives extensively using mutilation, including hand amputation, to punish harshly. For example, in Seljuk, Iraq, and Persia, executive agents use various types of mutilation against high status offenders, often accompanying execution. A particularly brutal instance unfolded in 450 or 1059, when executive officers commanded that the vizier, Ibn al-Muslima, be publicly displayed and sewn up in the skin of a bull that had just been flayed. The officials hooked 2 iron tongs under his jaws and then pulled him on the gibbet while he was still alive. They then let a crowd of people hurl insults and perhaps other things at him, and they left him there for an entire day until he eventually died. In addition, Seljuk officials used mutilation to punish gang-driven plunder, banditry, and military offenders in ways much more severe than Hadood laws authorize. For example, in the year 531 or 1136, when police officers arrested a number of suspects for the theft of thousands of dinars from a house in Baghdad, rather than impose a sentence of hand amputation, executive officials crucified the suspects, and they took property from each of them. Under the Mamluks, executives seem to have occasionally used hand amputation to punish theft, as when in the year 872 or 1468, the Sultan ordered hand amputation of thieves who stole sacred ornaments from shrines. More typically, though, sultans ordered mutilation punishments against repeat offenders. In 874 or 1469, the reigning sultan reportedly ordered one repeat offender to be hanged after two prior thefts that had presumably resulted in amputations. Other repeat theft offenders faced eye gouging and tongue extraction with shaming, imprisonment, and hanging, or various other modes of execution. What about stoning, with which I began? After hand amputation, stoning is the most storied and brutal punishment attached to and that Islamic criminal law might be known for, even if its designation as a punishment is of dubious textual origin. It's especially shocking to see the use of stoning to punish adultery in some Muslim societies today, where criminal codes have made a comeback and the implementation of them make the headlines. Other scholars have explored why stoning has dubious origins, such as Pavel Pavlovich, as have I in my book on doubt in Islamic law. But for now, let's discuss whether and how stoning did make an appearance historically. So upon review, the historical sources provide few reports and none unequivocal that claim to be judicial sentences of stoning. A review of all the main sources for criminal law from the Umayyad period through Ottoman times show that stoning applied as a punishment outside of the ordinary criminal punishment, if it applied at all. It was also a means of vigilante punishment, often for executive policies, and never for accusations of adultery, though occasionally for confessions of it. Aside from the vigilante violence, the sources record a sum total of 5 episodes of executive stoning sentences in medieval Islamic societies, all reported in Mamluk sources, one of them that I mentioned earlier. That incident that I began with was the one that unfolded in the year 919 or 1513. And recall that the Mamluk Sultan wanted to force the jurists and judges to impose a sentence of stoning against an adulterous couple. The judges refused and instead issued and signed a fatwa that deployed the doubt canon, which they took to mean the need to avoid the hudud punishment given the presence of repentance, which they read as a type of doubt. Of course, that did not drop the punishment altogether. They sentenced to flogging, a fine, and parading around. But Islamic criminal law did not permit what eventually happened, or what the Sultan demanded. So it didn't permit stoning as the Sultan demanded, and it didn't permit hanging as the Sultan eventually ordered. So as I also noted at the outset, the Sultan's dismissal of the juristic sphere of interpretation, his dismissal of the doubt canon, and his dismissal of the judges from the court likely contributed to the factors that led to his quick fall soon thereafter on the eve of the Ottoman takeover. He had adopted all Sharia interpretation illegitimately. So now we turn to capital punishment. Recall that capital punishment included the textually designated crimes of homicide, highway robbery, and murder. So Muslim jurists designated adultery, blasphemy, and recidivist theft also as capital crimes, the latter on a type of 3 strikes and you're out logic. As for historical practices, the sources rarely record impositions of in-kind punishments based on qisas laws, whether that be for severe corporal punishment or capital punishment. In ʿAbbasid and Seljuk societies, public execution for homicide appear infrequently in the sources, yet they were presumably commonplace and not spectacular enough to warrant more notice by the chroniclers. Other executions appear frequently under the Seljuks for a much wider range of crimes than homicides. The methods of execution included stoning for apostates by means of vigilante justice, drowning, burning at the stake, casting down from citadel towers and other heights, stuffing into pits head first, suffocating, crucifixion, not always before death, trampling by elephants, and various forms of torture to death. So these means are far outside of the authorized means on the books in Islamic law. In the early 6th or 12th century, for example, suspected heterodox groups called Batanis were drowned in the Tigris River. And this and similar executions were instances of executive justice against those who threatened or offended the sovereign directly. In Mamluk sources, homicide was the single most reported on crime, approximately 150 cases. Homicide's many reports were no doubt due to its rampant occurrence in the large metropolises of Damascus, which had about 100,000 residents, and Cairo, which had about 250,000 residents. These populations were this large even after the Black Plague of the 14th century. The high rate of homicide reports was also likely due to the degree to which it would upset societal cohesion and safety. Most reported homicides resulted in prison or execution, that is, when the perpetrators could be caught. About half of the recorded perpetrators for reported incidents evaded arrest, and another 1/3 escaped. During the same period, Mamluk sultans treated Bedouin raids as capital crimes, and sultan ordered their execution by crucifixion and bisection, flaying, hanging, and all out hand-to-hand combat and execution as if in battle. And then they punished extensively whenever highway robbers could be caught. Of the 12 incidents reported throughout the Mamluk period, only 1 highway robber was spared execution, and that was a diplomatic offense involving the taking of a diplomatic pouch carried by an ambassador from the Ottomans to that last sultan, Al-Ghawri. Finally, executive officials often treated blasphemy, apostasy, and dissident acts as capital crimes. Under the Abbasids, the single most dramatic and memorable state-sanctioned execution was that of the figure Mansur al-Hallaj, the Sufi mystic who had amassed a large following, but he diverged from an emergent Sunni orthodoxy. And so he was deemed a threat for many reasons. First, he had created several political enemies. Second, he enjoyed widespread influence at a time of political instability. And third, his followers represented a real and present danger to the caliphate at Baghdad at the time. So in the year 296 or 909, his followers helped engineer a 1-year takeover of the caliphate of Baghdad, only to have the infant caliph al-Muqtadir reinstated under the tutelage of his vizier, Ibn al-Furat. 1 year later, some of his leading disciples were behind another failed attempt to seize power. And to be sure, the composition of Hallaj's followers makes clear that the threat he posed was not against Sunni orthodoxy per se, Rather, it was to threats of the Sunni majority political establishment. Consider this, his most vocal supporters were staunch Sunnis. They were Hanbali activists and one Shafi'i jurist. Meanwhile, the vizier Ibn al-Furat, who opposed Hallaj, was Shi'i. Hallaj escaped punishment for his so-called heresy for some time, but he eventually met his death in Baghdad. Law enforcement officials arrested him in the year 301 or 913 in the wake of the second coup attempt against the infant caliph. His supporters, the Queen Mother and the Grand Chamberlain, as well as that Shafi'i jurist, Ibn Surayj, managed to avoid a capital trial in favor of palace imprisonment for nearly 9 years. During that time, Hallaj's old supporter, Ibn Isa, had taken over the vizierate once again, but his friend, this new vizier, became involved in a fight over fiscal policy with the powerful tax collector and former vizier named Hamid. To gain the caliph's favor and to demote Ibn Isa, Hamid managed to reopen the trial against Hallaj by enlisting the support of the famous Quran reciter, Ibn Mujahid. At the same time, Hallaj's Hanbali supporters sparked public unrest to protest Hamid's actions, and they even placed the famous and well-respected historian Ibn Jarir al-Tabari, the one who died in 310 or 923, they placed him under siege for censuring their recourse to violence. All of this only further empowered Hamid, who was appointed to restore order. Eventually, he worked out the terms of a capital sentence for Hallaj with a local Maliki judge, likely chosen for his school's accommodationist stance to those in power seeking capital punishment against criminals and against enemies of the state. So the end unfolded like this. In a state of ecstasy or connection with the divine, that the establishment took as challenging God and the Sunni establishment, but that fellow mystics saw as the obliteration of the ego into God, Hallaj declared, "I am reality," or in another translation, "I am the truth," al-haq, another name for God. Over the objection of the Shafi'i judges and jurists, and on Hamid's charges of blasphemy, the Maliki judge presiding over the capital trial issued a death sentence in the year 309 or 922. And thereafter, Hamid enlisted representative members of the elite from the Muslim community to cry out at the execution that Hallaj's death was necessary, quote unquote, for the salvation of Islam. Amid these cries, Hallaj was flogged, his hands and feet were cut off, he was crucified and left overnight, and finally beheaded, cremated, and his ashes were spread to the winds outside the gates of Baghdad. So following these grisly events, scholars of ʿAbbasid, Mamluk, and Ottoman legal history thereafter detailed several executions, also on bases of alleged heresy. As with Hallaj, blasphemy, heresy, or even theological diversity were not really the thing at issue. Instead, it was political machinations and perception of threat to establishment authorities' power that led to executions in virtually every single case. What about the role of prisons? The carceral punishment. So incarceration is a punishment form that arose in medieval Islamic societies principally through executive practice, or siyasa. Prison doesn't find explicit mention beyond home confinement in Islam's foundational texts, including in the Quran, nor does it find extensive treatment in the mainstream works of Islamic law. However, by Islam's second century, so as early as 2 centuries in, incarceration had become a widespread practice, and it came to have a prominent place in Islam's criminal justice system. The closest the Quran comes to removal from the home is banishment from society itself, that is exile for sowing corruption in society, according to Quran, Surah 5, verse 33. Banishment from the tribe was a pre-Islamic punishment that seemed common enough in early Islam, as attested by banished brigand poets from the Umayyad period. But thereafter, with very few exceptions, exile seems to have been far rarer than prison in medieval Islamic societies. Rather than banish as punishment, late ʿAbbasids primarily used exile to remove high government officials and from rival political positions. Under the Seljuks, exiles would be sent to a far-off city, but still somewhere within the empire. For example, that famous vizier, Nizam al-Mulk, sent his predecessor to Merv and was himself sent away by the vizier who came after him, Abu Shuja al-Rudwari, when that new vizier took over in the year 484 or 1091. But it's underappreciated and it's often under-discussed in studies of the history of Islamic criminal law that prisons were widespread in almost every arena for all manner of crimes and used for both the most vulnerable and the most influential in medieval Islamic societies. By the 8th century, prison use had apparently become so widespread that the prominent Hanafi jurist Abu Yusuf, who worked closely with the Abbasid government, faulted the state for its overuse, and he complained that prisons had all but replaced divinely legislated Hadood punishments. He urged officials to return to the use of Hadood punishments to remediate increasingly crowded prisons. Then and thereafter, jurists came to regard prisons as overused, and they said as much in their legal writings. So centuries after the complaint from Abu Yusuf, the Shafi'i jurist Mawardi, who died in the year 450 or 1058 in the East, and the Zahiri jurist Ibn Hazm, who died a few years later in 456 or 1064 in the West, that is in Al-Andalus, they amplified the earlier complaints against the overuse of prison. Just as had Abu Yusuf in 8th century Baghdad, these jurists complained strongly about the overwhelmingly widespread practice of using prisons instead of Hadood punishments in their far-flung regions of Greater Persia and Al-Andalus, respectively. And following them, Mamluk jurists and historians noted and also complained about the use of prisons in Egypt, Syria, and Greater Palestine. So with that landscape, let's conclude and sum up what we have covered. So this talk has attempted to highlight and illustrate this very striking feature about medieval Islamic criminal law that contrasts and juxtaposes legal principles against historical practice, juristic interpretation against raw executive power, a jurisprudence of doubt and lenity against political practices of control and severity. And in the process, I've hoped to answer the questions with which I started, showing first that there was a divergence between Islamic criminal law principles and the practices, and then explaining why and how they emerged and persisted. In short, I can say the following, that the law expressed moral opprobrium to crime, and its actors were intensely concerned with the procedural and substantive fairness of a limited set of punishments that they could thereby justify as legitimate under the divine gaze. At the same time, realpolitik reflected political realities of precarious borders, unsafe streets, and tenuous holds on political power. Executive actors were in turn intensely concerned with holding on to power and exerting social control through criminal law. There is much more to be said on the broader theories that justified Islamic criminal law. For example, in addition to a need to further explore the political actors' need for social control against that backdrop of instability, precariousness, and violence in the medieval world, this cursory review raises further questions about what really undergirded the legitimacy that jurists saw and typically expressed as the reason, the justification for criminal law. They expressed it in two ways: this worldly utilitarian aims of deterrence or zajr, and otherworldly terms of spiritual rehabilitation, kafara. Meanwhile, the executive justifications, aside from maslaha or public interest arguments underlying executive policy or siyasa shari'a, these executive justifications seem to be more about social control, political insecurity, and structural power on a model of might makes right. There is thus much more room and need for rethinking Islamic criminal law along these and other lines. And I suggest there is more of a basis for doing so given the recent developments in criminal law theory today that can meaningfully be brought to bear on our discussions and understandings of medieval Islamic criminal law from yesterday. I seek to take up that task through discussion about these examples here and in conversations with scholars interested in exploring the evolving theories and policies of criminal law in comparative context. Thank you very much.
Muchas gracias, Intisar, por este exhaustivo repaso.
Thank you very much for your talk on the principles and historic practices of Islamic criminal law.
My pleasure. Thank you for inviting me.
Bienvenida. Es una presentación, además, tal como ella lo ha presentado, pues lo ha hecho de una forma muy clara.
Your presentation was very clear and accessible to all types of public, both experts and people who do not work in the field of Sharia and are not experts in the field of Islamic criminal law. She has insisted on the need to continue to interpret Sharia in legal terms. Jurists and experts are in charge of that. And she has also talked about executive power, which in some cases has acted against the thinking of jurists. History is never a fairy tale, but in any case, I think that her talk has been interesting because we have learned important concepts, we have acquired historic evidence so that we do not consider Sharia as a law with the single aim to provide arbitrary justice. She has given us many good examples. We've seen cases of the sultans and his agents applying justice in order to creep to power, to continue to rule and apply laws to their own benefit. Thanks to her talk, we have learned how that legal system works in the end, Islamic criminal law is a system which is similar to other more modern law systems. Nowadays, we punish some behaviors such as adultery, for example, but not in our society, but they used to do. So she has made a comparison between crime and punishment in Islamic societies. She has taught us about the different justifications for crime and punishment. She has talked about silos and about the plane that there is between the silos. She has talked to us about how criminal law has been applied through different periods in histories. She has highlighted medieval criminal law. She has talked about jurisprudence of doubt, about lenity, and about abuses by executives. And she has said that we have to continue to study the topic, paying attention to legal norms and practices and to the current laws. So, Professor Intisar Rabb, thank you very much for participating in our cycle of conferences. I do hope we can translate your text into Spanish and publish it, because in our country it is going to be very influential. It is a very clear text.
Importantes precisiones que ella ha hecho para evitar
with very good examples.
Bueno, evitar en la medida de lo posible sin caer en fin, en paternalismos y sin pretender adornar.
Because the idea is to avoid distortion and misinformation regarding Islamic criminal law. There is a lot of confusion in this topic, and it is important to avoid confusion, especially for contemporary Muslims. Sharia is key to know as much as possible of it. I'll give the floor to Javier to conclude. Thank you, Professor. Thank you for your speech.
Reiterar las palabras de Delfina.
I don't want to insist too much and repeat anything, but I would like to say that our conference cycle should be considered as a whole. Sharia is a complex issue. There will be many talks, many cross-cutting talks on Sharia, tackling different concepts. It is a complex issue for non-experts as well as for experts in many cases.
El aporte que nos has dado creo que es de suma importancia.
Intisar's approach is very important.
Que hizo Delfina en su momento
para the introduction we made at the beginning has been key in order to know the key terms before the beginning of the cycle of conferences, like the canon of doubt, for example.
En castellano,
que you have to consider the translation into Spanish as well.
Confía en que sí, que lo vamos a traducir y que el texto va a estar disponible para...
Your text will be translated and will be made available to everyone interested on this topic. So please watch the first conferences of the cycle, because the cycle of conferences should be considered as a whole. We have to consider each conference as a building block in order to know what Islamic law is about. Thank you very much. And see you soon. See you in September. We will continue to publish material on our website, and thank you very much. Thank you. Enjoy the summer. Bye. Thank you.